Our next speaker, our next topic is bankruptcy. Our next expert speaker is Stephanie Lee. She is like one of these people that comes from the other land. She comes from the business side, and every time I talk to her, I'm always amazed at how much she knows and how clearly she conveys it. She is one of the 70 board-certified business bankruptcy lawyers in the state, which is a very rare...
70.
70. 77? 70.
No, she said 7. And
oh, got it. She knows her stuff. Welcome, Stephanie Lee.
Thank you.
Okay. I don't know what I did to deserve the coveted 2 p.m. on a Saturday spot, but I'm going to do my best for you guys. Let me see how to move this forward. Oh, boy. All right, so I am tasked with giving you an overview of bankruptcy law generally and issues that you all may encounter on the exam. This is going to be lightning fast, so if you have questions, just call, and I'm happy to answer any questions that you have. The primary purpose of our modern bankruptcy law is to ensure orderly reorganization or liquidation and division of assets. What we say is it's designed to let the honest but unfortunate debtor have a fresh start, allowing them to stop their creditors from pursuing them and hopefully get a discharge of their debt and restructure their relationships and long-term obligations. It is to ensure that they have a breathing space so that they can reorganize, and also that creditors have fair and equitable treatment. We speak in code, the bankruptcy code. We do that so you can't understand what we're saying, and it's really a matter of job security. Let's go to the type of bankruptcies that we have. So there's basically 6 different types of bankruptcies. These 3 here, you really are never going to deal with. Municipalities, foreign proceedings, and I mean, maybe occasionally a family farmer. But you know, you really don't need to worry about those. The 3 that are the 3 main areas of bankruptcy are the chapters 7, 11, and 13. So I'm going to try to break those down for you. Let's start with chapter 7. Chapter 7, here we go. Next year, I'm not going to do all these bullet points here. Chapter 7 is purely liquidation. It applies to both individuals and corporate entities. In a Chapter 7, a trustee is appointed. A Chapter 7 trustee is appointed, and their job is to gather and liquidate the assets of the estate and distribute those assets to creditors in accordance with the priority scheme established under the Bankruptcy Code. Make sense? Okay, so on the petition date, the Chapter 7 trustee takes possession of everything, but they don't have the ability to operate unless they get special permission, which is basically never granted. So it's a shutdown situation for any business in a Chapter 7. So, and with some exceptions, the individual Chapter 7 debtors are to get a discharge, right? Corporate entities who file for Chapter 7 do not get a discharge. They're just dead. Does that make sense? Okay. Not all individuals are allowed to file for Chapter 7. Chapter 7 is kind of like the best case outcome, even though, you know, if you're in bankruptcy, it's not a great outcome to start with. But you get a discharge of all your debt and you truly get a fresh start. But in 2005, there was a means test put in place that said, well, listen, if you have the ability to repay some of your debts, you're going to have to put a plan together to repay some of your debts. So some people don't qualify for Chapter 7 and they have to file for Chapter 13. Okay, Chapter 13 is just like Chapter 7 is purely a liquidation. Chapter 13 is purely a reorganization, and it's only available to individuals. So in a Chapter 13, a debtor has to repay some of their debts. Here we go. They have to repay some of their debts under a plan, and then they don't get a discharge until they've completed their plan payments, right? So they have to file their Chapter 13, they put a plan in place, there's a Chapter 13 trustee that comes on board, but they don't have the same job as a Chapter 7 trustee. Chapter 7 trustee comes in and takes over. Chapter 13 trustee is kind of just oversight over the debtor who stays in possession of all of their assets and carries out their plan. The plan is confirmed, and the Chapter 13 debtor has like 3 to 5 years to repay their creditors based on their disposable income, and that's a test under the bankruptcy code. This slide is wrong on the unsecured and secured debt. The new number is 2.75 million of contingent, non-contingent, unliquidated debt. So that's Chapter 13 generally. Mostly people in Chapter 13 go to Chapter 13 because they're way in arrears on their homestead, and so they do what we call a cure and pay plan, which means you take, all right, say you're $100 behind on your mortgage payments. You go and make your going forward mortgage payments, and you take that $100 and you split it up over 5 years so that at the end of your plan, you come out current on your mortgage, right? So that's like what we call the cure and pay plan. All right, so let's talk about Chapter 11. Chapter 11 is commonly referred to as a corporate reorganization, but it's really misleading because it can apply to non-corporations and to non-reorganizations as well. So in most cases, our corporate Chapter 11s, but if you don't qualify for a Chapter 13 and you don't qualify for a Chapter 11, you could find yourself in an individual Chapter 11 case. They are also not limited to reorganizations. They can be used to effectuate orderly liquidations of assets or sales of businesses as a going concern. I will tell you, most Chapter 11s that I see are sales. They're really not, the large majority of them have not been in my career true reorganizations that you think of when you think of a Chapter 11 reorganization. So in a Chapter 11, and if we have time, we'll get to the more nitty-gritty of this, but in a Chapter 11, the debtor proposes a plan of reorganization or to liquidate, and the treatment of the debts, and creditors vote on that. In 2020, there was something called Subchapter 5 enacted. Any of you saw that in the news? Y'all are not focusing on bankruptcy news in 2020? Okay. It's a small business reorganization that made it easier for smaller businesses to file for bankruptcy, to get to restructure their debts, because Chapter 11 is quite an expensive proposition. All right, so we're going to summarize here. You have in Chapter 11, the debtor stays in control. They put a plan together. They can sell or reorganize. In a Chapter 13, that's an individual plan, and that's really usually what we call the cure and pay on the homestead. And then the Chapter 7 is really a complete reset button, but you have to pass the means test to get to that point. Got it? Okay, so those are the chapters. I'm going to talk a little bit about the ground rules. And last year I ran out of time and Lloyd got really mad at me, so I'm going to talk really fast. What's that? I promise to be on time this time. All right, so the ground rules apply to all the chapters. The date on which the bankruptcy case is commenced is referred to as the petition date. Why? Because you start a bankruptcy case by filing a petition. One of the most important restrictions on the operation of a business in bankruptcy is how property of the estate can be utilized. A trustee or a debtor in possession can do a lot of things they want to do as long as it's in the ordinary course of business. But if it's not in the ordinary course of business, they have to seek permission from the bankruptcy court. Has anyone heard of the automatic stay? Please say yes. Okay, what is it? The automatic stay is the most important aspect of bankruptcy that a non-bankruptcy attorney should know, because it is the part that can get you into lots of trouble. Okay, and then you'll have to call me, I'll have to defend you, it will be awkward. So, the automatic stay is in essence an injunction directed to anyone with notice or knowledge of a bankruptcy prohibiting most forms of collection or enforcement of your claim. As it suggests, it is automatic, and only with rare exceptions does it not apply when the bankruptcy is filed. So the 11th Circuit, most important thing to know, the 11th Circuit says that any act taken in violation of the automatic stay is void and without effect. So there is no point in trying to sneak one past anybody, because what you do is void ab initio. All right, so we're going to talk about automatic stay violations. The consequences of violating the automatic stay are all bad. Okay, willful violations of the automatic stay have serious consequences. So they're all void ab initio, that's the magic word, void ab initio. So that means that there's no need for anybody to do anything to declare this act that you did on violation of the stay void. It just is, it has no force or effect. So if you try to get it in, it didn't work, right? The debtor can recover, it says under the statute, if you violate the automatic stay willfully, the debtor shall recover actual damages, including attorney's fees and costs, and they could recover punitive damages against you. Where most people get into trouble is the whole willful thing. You think, well, I didn't willfully do anything, but the definition of willful is, did you mean to do what you did? It's not like this, bad intent kind of thing. So I myself am more of a ask forgiveness rather than permission kind of gal, but not when it comes to the automatic stay. You got to ask permission, okay? Yep, Steph, we got it. All right. So I think I already said that. All right. So how do you do that? All right. Creditors and other parties can seek an order from the bankruptcy court granting them relief from the automatic stay. There's mostly two different bases. There's a lot of different bases, but the main two are for cause, including a lack of adequate protection or like bad faith. And then the other one is under 362D2, which is if the debtor does not have any equity in the property and you're the secured creditor, and the property is not necessary for an effective reorganization, either because it's really not necessary or because the debtor has really no hope of an effective reorganization. Those are the two main bases to seek relief from the automatic stay. But when in doubt, we have a whole process where we file a motion to confirm that the automatic stay doesn't apply. And our bankruptcy judges are really always willing to issue you an order, like what we call a comfort order, just so you see your A. Okay? So what happens if you ask for relief from the automatic stay and you don't get it? Your consolation prize is the term adequate protection, okay? All is not lost. If you don't get stay relief, instead, you may be able to get adequate protection. What is adequate protection? It is based on the concept that the secured creditor, and it's only available to secured creditors, but the secured creditor should not have its security diminished, the value of its collateral diminished because of the bankruptcy case. So there should be some mechanism that makes sure that the creditor's lien position on the petition date is the same as it is at the end of the case, so that you don't have a diminution in value of your collateral, right? So a secured creditor will generally be entitled to adequate protection on a showing that the value of the property is in jeopardy or decreasing or being diminished because of some reason, either because the debtor's not paying the taxes, or there's, and liens ahead of you are starting to, grow, or they don't have insurance, or, they're putting your collateral at risk. So what are the types of adequate protections you can get? I'm going to tell you right now. Hold on. Wait for it. Oh, crap. All right, I'll tell you. Cash payments, monthly cash payments, which is like what we always want, right? A replacement lien to the same extent, validity, and priority that existed pre-petition. You get the indubitable equivalent of your collateral, which is a bankruptcy word that nobody really knows what it means. But sometimes the debtor will say, well, no, there's equity. There's an equity, you have an equity cushion in the property, so you don't even need payments. Your adequate protection is that if your collateral, if somebody is ahead of you, it doesn't erode your collateral position because there's equity behind you. But always we ask for insurance. Insurance is a big thing in bankruptcy. So then you'd be listed as a loss payee kind of thing. Okay, so next question is, how long do I have to tolerate this automatic stay? The answer is forever. Unless you get stay relief, the stay is going to continue until the case is closed, the case is dismissed, or the debtor is granted a discharge. However, like you think, oh, great, they'll get a discharge, then I won't have an automatic stay. No, it doesn't really work that way. After the automatic stay, when there's a discharge, the automatic stay is replaced with a discharge injunction. So the answer is really never. Okay, so until the property, when we're talking about just property itself, how long does the stay last? It is until the asset is abandoned, right? Or it's deemed exempt, or a plan is confirmed, and then the plan treatment is substituted in for the way you're going to be treated. Okay, so basically, the automatic stay goes into effect. You have to funnel everything through the bankruptcy going forward, and your fate is determined by the bankruptcy court. Does that make sense? Okay. Oh, there's more stuff. All right, so let's talk about single asset real estate cases. I'm only going to do this quickly because I have 14 minutes. The single asset real estate entities, SAREs, are the subject of another set of rules that are found in 362D3. And this single asset real estate entity definition was created and it's meant to protect against abusive filings by debtors, okay? So in those cases, if the debtor is a single asset real estate entity, a creditor whose claim is secured by a lien on that real estate is entitled to stay relief unless the debtor does some stuff, right? They've got 90 days from the petition date to either file a plan that the judge says has a reasonable proposition of being, reasonable likelihood of being confirmed, or they have to start making monthly payments. They can't just run into bankruptcy court and sit there and do nothing and run out the clock to try to delay you. Right? They have to make interest payments. They've got to do something. I will warn you, and this may shock you. I'm glad you are all sitting down. Sneaky debtors sometimes try to avoid the characterization as a single asset real estate case entity because they don't want to pay you. I know it's crazy, but it happens, so watch out for it. All right, so I'm going to skip over some of this, but if you have questions about single asset real estate bankruptcy cases, I'm happy to chat more about them with you offline. The last thing I'll say is if they don't do the things they're supposed to do in the first 90 days, it's subject to dismissal or lifting the automatic stay so you can go proceed and get your collateral back. Okay, so the next concept we're going to talk about is proofs of claim. Everybody heard of a proof of claim? So when I said, everything funnels through the bankruptcy case, the way you protect your client's interest is to file a proof of claim. It has to be filed timely. There is no forgiveness. There is no late filed claims. I mean, a motion to allow a late filed claim doesn't get granted very often. So you got to make sure that that's the very most important date that you calendar when there's a bankruptcy case is what is the proof of claim bar date. Even though a secured creditor doesn't really need to file a proof of claim to preserve its lien, they do have to file a claim to participate in distributions in the case. Do you understand the distinction? It's not like your mortgage goes away, right? But if you want money out of this bankruptcy case, you have to file a proof of claim. I'm going to give you a practice tip, and I want you to repeat after me. I will never sign a proof of claim on behalf of my client. Okay? This is just if you take nothing else away, do not sign proofs of claim on behalf of your clients. Nothing good can come of that for you, okay? Make your client sign the claim themselves. All right, so if you have a proof of claim, you look at the form, there is a field in there to, if you're a secured creditor, to allocate to list the value of the property and allocate between your secured status and your unsecured status. And that's where we get into valuation and how valuation is dealt with in bankruptcy. Have you ever heard of the concept of lien stripping? In bankruptcy, we have all these rules and you can strip down a lien. So let's say I have a piece of property that is worth $100, but my lien is for $125. My secured claim is only $100, right? Because I'm only secured to the extent of the value of my collateral. Do you understand that concept? So if the property is worth $100 and I'm owed $125, I have a secured claim of $100 and I have an unsecured claim of $25. In bankruptcy court, the debtor can go in and file a motion or file an adversary proceeding to strip down your lien to the value of your collateral. In certain circumstances, there are exceptions. Can't do it on homesteads. It's a whole thing. But that's just a concept I want you guys to understand. Okay. We're going to talk about the next concept is use, sale, and lease of property of the estate. We talked about earlier that sale of property of the estate is allowed except if it's outside the ordinary course of business, which is usually pretty obvious, whether it's outside the ordinary course of business. When in doubt, ask permission. One of the benefits, and I think this is arguably the biggest benefit of Chapter 11 cases these days, and it's available in Chapter 7 and 13 as well, is you can sell in a bankruptcy free and clear of all liens, claims, and encumbrances, regardless of the debt on the collateral, right? Because of this lien stripping concept, the asset's worth what it's worth. It can be sold for what it's worth in a bankruptcy. All the liens, it's sold free and clear of all liens, claims, and encumbrances, with those liens, claims, and encumbrances attaching to the proceeds and being distributed based on priorities. You get that concept? Okay, so 363F is the bankruptcy code section that allows a trustee or a debtor in possession to sell free and clear of liens. It has to meet one of these 5 criteria that you can see on the screen, and the bankruptcy court will approve it. The reason it is so powerful is that sales under bankruptcy court under 363 are not usually susceptible to attack on appeal. If there is a 363M finding that the purchaser purchased for value and in good faith, then even if the sale order is later reversed or modified on appeal, it doesn't affect the validity of the sale. So it's kind of like an equitable mootness thing, right? So another benefit of 363 sales in the Chapter 11 context only is that if pursuant to a plan, the asset is sold, it is sold without the need to pay documentary stamp taxes. So, I mean, what are doc stamps these days? Like 40 cents for something? I don't know, for every $1, $100, something. Anyways, it adds up. Okay, so let's go quickly, 7 minutes, to Chapter 11 cases. We've covered some of the basic concepts, digging a little bit deeper into Chapter 11 plan process. A lot of commercial real estate dispositions happen through Chapter 11 plan process for a lot of reasons, not the least of which is the doc stamp thing. So in a Chapter 11, the debtor will propose a plan. Maybe it'll be called a plan of reorganization. Maybe it'll be called a plan of liquidation. They have to file a disclosure statement, which gives a lot of information about the background and how they expect to implement their plan and the feasibility of their plan, and then the plan itself. And creditors vote on whether to accept or reject the plan. Creditors are separated in a plan into categories, right? So there's at least one class for secured claims, one class for unsecured claims, and one class for equity interests. If there's more than one secured creditor, each of those creditors gets their own class. And then there's treatment listed there, right? Classes of creditors whose claims are impaired, meaning they're not getting what they bargained for under their contract or under their agreement. They are impaired and they're entitled to vote. Confirmation of the plan requires approval of all classes of creditors by a vote of 2/3 in amount and half in number of voting creditors, okay? Well, what happens if you don't get the vote? Then you can go to what's called a cram down. If you don't get the vote of everybody, but you get one impaired class of creditors voting in favor, you can ask the court to go, Judge, I think this is a fair and equitable plan. They didn't, not everybody voted, but I think you should cram those objecting creditors down and approve the plan anyways because it's fair. Have you ever heard of cram down? Anybody heard of these concepts? Okay. The plan cannot, in order to cram down, it cannot unfairly discriminate. It has to be fair and equitable. And there's all these definitions of what that means. A little bit further. And we go to I don't think I have time for the absolute priority rule, but we'll keep going. All right, so avoidance powers. Another concept that you may run into in the bankruptcy world is avoidance actions. Has anyone had a client receive a preference demand letter? Ever? Okay, fraudulent transfer? Okay, at least one of you. In bankruptcy, Chapter 5 is where you find avoidance actions. There's two main types of avoidance actions. There are preferential transfers and there are fraudulent transfers. But the moral of the story is a trustee in bankruptcy is given superpowers to avoid transfers that happened before the bankruptcy case, right? And bring those assets back into the estate to be distributed equally among creditors. Preferences are the ones that make your clients the most upset, really, really upset. And it's because nobody did anything wrong in a preference situation. Preferences are avoidable only because they indicate that one creditor was preferred over another creditor in the 90 days before the bankruptcy case. It's like the squeaky wheel gets the oil kind of at the end when everything's going down. And they want to say, all right, well, that wasn't fair to the other creditors, so let's bring all that money back into the estate and distribute it pro rata among unsecured creditors. So these are the elements of a preference, right? It has to be a transfer of interest, from the debtor to the preferential transferee on account of an antecedent debt while the debtor was insolvent, and the debtor is presumed to be insolvent in the 90 days before the bankruptcy, and it allows them to receive more than they would if the preference hadn't happened. Well, duh, that always happens, right? So in the context of an insider, though, they take that 90 days and they extend it to a year, because who knows what kind of funny business is happening with insiders in the year before the bankruptcy. There are defenses to preferences. There are three main defenses: ordinary course of business, contemporaneous exchange of new value, and subsequent new value. So if your clients ever get hit with a preference demand, they're going to be very upset because they usually didn't get paid in full, and that was just what they got paid, in the 90 days prior. But there are defenses. It's a very formulaic approach to defending preferences. I mean, I've defended thousands of preferences. It does make them very upset, though. Then the next one, and this is my last concept, is fraudulent transfers. Fraudulent transfers there are two different bases for fraudulent transfers in the bankruptcy world. There is fraudulent transfers under the bankruptcy statute, right, under 548, which is the 2 years before the bankruptcy filing. And then, because I said the trustees have superpowers, they can actually use the state court fraudulent transfer statute to go back 4 years and look at fraudulent transfers that could have happened 4 years before the bankruptcy petition. There are two different types of fraudulent transfers under bankruptcy law, just like there are under state law. There are fraudulent transfers that are done with the actual intent to hinder, delay, or defraud creditors, and that requires proving fraudulent intent, and the case law says that you do that by proving these badges of fraud, and there's like a dozen badges of fraud in the case law. Okay, those are harder to prove. The easier ones to prove are the constructively fraudulent transfers, which is really like, did anyone really do anything wrong? Probably not, but the transfer was made for less than reasonably equivalent value at a time when the debtor was insolvent or became insolvent as a result of the transfer, right? If it's a gift, that's an easy one. You don't have to prove that you intended to defraud anyone. It's just that they didn't pay anything for it, right? Or they paid very little. They did not pay reasonably equivalent value for the transfer, and as a result of the transfer, they are insolvent or became insolvent. Okay, I have 1 minute left. I did a good job. Does anyone have any questions? Not all at once. No questions? Okay, well, if you do have questions, you're welcome to email me. Can't make it go any further. Oh, there I am. That's my phone number and my email address. I'd be happy to answer your questions, and good luck on the exam. Thanks.
Alan Fields has a depth of experience and a willingness to work, which is and a level of intellectual ability that's amazing. Alan is the former Executive Director of the Florida Land Title Association. Whatever you need to know in our area, he knows. He literally this morning, on the death side, the Homestead speaker came down with COVID. Alan was going to be the speaker. Whatever you ask Alan to do, Alan has the depth and breadth to do it, and he willingly and graciously does it. Alan is one of the heroes that always shows up.
Wow, thank you for those kind words, Lloyd. Unfortunately, they don't extend to my speaking ability, and my goal today is not to put myself to sleep. Last year I ran a little long, so I'm going to be talking a bit faster today and skipping over some of the slides, and you'll benefit by that. I will try to get to the questions that were raised about navigational servitude and circle back as we get there to why we have this ugly sovereignty lands exception in all of our title policies in Florida. In this session, we cover a whole lot of history and some black letter law. And as we go through, there's a couple of themes I want you to be on the lookout for. The first theme is that as real estate lawyers, we are always looking to the official land records as our source of truth. If it's not recorded, it doesn't count. Basic Recording Act, Marty's going to talk about that in a few minutes. When we're talking about waterfront property, water rights, there are a series of non-record title transactions that are the bugaboo that give rise to a lot of uncertainty. So watch for those as we go through this. The second is that Florida started off very much following the national model. A lot of judge-made law, common law, set the rules for waterfront property and water rights. And like most judge-made rules, they evolve and change over time, just as we learned in our con law classes, right? You'll see that here. Those kind of changes tend to bother us as property lawyers, where we think the bundle of sticks and your property rights should be immutable and unchanging. So watch for that theme as we go through. Also watch for a much more minor theme, that the rules as regards privately owned, artificially created water bodies or artificial expansions of a water body are subtly different from the rules that govern something that God created. So as we go through that, let me get started with the fun stuff. We'll skip that one. For those taking the quiz, there's a couple of new, relatively recent cases. You'll find much more detail on page 5 of your materials. First one is Florida DOT versus Lauderdale Boatyard. Stands for long-standing concept. If you have riparian rights, it's because your property reaches the edge of the water. This was a situation in which there was one property and then another property fronting on the water, and that property owner dredged out to the point it actually reached the property further from the water. And the holding of this was that no, the property that got dredged out didn't have the riparian rights because it didn't have natural contact with the water. There was somebody else's lagoon, if you will, between them and the part God created. The 5F cases are a subtle twist on that. 5F and Hillsborough Inlet are both one of those scenarios where somebody has acquired title to lands between a riparian owner and where they want to get with their boat or their dock and tried to extort monies out of them. The 5F cases reiterated that the riparian owner has that common law right to construct a dock out to navigability to cross somebody else's privately owned submerged lands, whether they got it from the governor and cabinet or by some other means. if they have the riparian rights. And that's the distinction between that and the Lauderdale Boatyard cases. The Hillsborough Inlet case is a subtle twist on that, because the reason there's private ownership under a portion of Hillsborough Inlet is it was part of the Intercoastal Waterway. And there was a federal condemnation that acquired the the easement for it. And that's going to be an interesting twist on it. That case is still working its way through the systems. Watch out for it. It could be very interesting to watch because of the federal condemnation overlay in that case. Okay, some black letter law and a lot of history very quickly. Florida became a state on March 3, 1845. Every new state in our nation, upon becoming a state, automatically acquired title to all of the sovereignty lands in the state. Happens automatically. It's a non-record transaction, meaning no deed, no conveyance records, no legal description, just poof, it belonged to the state of Florida. What are these sovereignty lands I'm referring to? And this has been a question in prior years. It's all lands beneath navigable waters and all lands beneath tidally influenced waters, whether those are themselves navigable or not. So if you've got a salt marsh that's a half an inch deep at high tide, that's enough to have been sovereignty lands, and it passed to the state. Key there, non-record transaction, no conveyance documents. Shortly after we became a state, Missouri was in the process of becoming a state, and like Florida, they were a tad damp. And the lobbyists pushing for Missouri to become a state encouraged the passage of the Swamp and Overflowed Lands Act, which for the first 4 or 5 sections of it basically said, we're doing this for Missouri. We're going to give Missouri all of the swamp and overflowed lands inside their state because we think they're worthless anyway, and they might be able to do something with them. Then in section 5, it says, oh, and all the other states can have their swamp and overflowed lands too. Applied only to current states, not to future states. And Florida was off to the races. They claimed 20 million acres plus were swamp and overflowed, basically everything south of Gainesville. 2/3 of our land mass, and it was gifted to the state of Florida from the feds under this act. As with all later admitted states, the original colonies, this didn't apply. Thomas Jefferson had this wonderful idea: we're going to call on all of the lands in new states to be laid out in sections, townships, and ranges. And they engaged surveyors, they turned them loose in the state of Florida and created the section township range system that we're all familiar with and that I believe Rick Taylor is going to be talking about tomorrow. Those surveys became the basis that was used by the state of Florida and by the federal government to sell off the remaining lands. Now, as part of the survey instructions, one of the key instructions was, surveyors, when you find a navigable water body, you must meander it. Now, what is meandering? It's just drawing a series of straight lines that roughly track the shoreline that allowed them to use high school trig to calculate the area that was available for sale. And when they came across a non-navigable water body, the survey instruction said, sketch it out anyway, but you don't need to locate it with meander lines. And this is one of those original surveys. This happens to be in Polk County, and we'll see the significance of this later. When the surveyors did this, they found nothing they considered navigable. But they still located a number of ponds that you can see, a river, several tributaries to that river running north-south. And when somebody went to buy a given section or one of the government lots, which were how they figured along the top and down the west side, They didn't always measure exactly right, but by the time they closed out the square, they could calculate how far off they were. And they just allocated the shortage or the excess to those government lots. And that table in the upper right spells out how many acres are available in each of the government lots. And when they sold one of them, even if they knew there was a pond in it, even if they knew the river ran through it, they charged the set rate per acre for the whole thing, wet or dry. This is one where they found navigable waters. This happens to be the lower reaches of the Peace River down at Punta Gorda. Much wider here. The dark black lines, this was used as an exhibit in a lawsuit. And the dark black lines where somebody highlighted it and it scanned dark black. The table in the upper right there shows the distance and angles of each of the meander lines. And then the table down to the lower right shows the acreage that was available. And if you bought down in Punta Gorda, you only bought the dry lands based on this map. Next piece of black letter law, and you remember this from law school. Water boundaries move. Gradual and imperceptible natural changes move the boundary between public and private ownership. We have several fancy names for them: erosion, accretion, reliction, but it's all characterized by it being gradual and imperceptible. You don't see it happening day to day. On the other hand, an evulsive change, sudden, artificial changes don't move the boundary. So if a hurricane comes through and cuts a new pass, if some of Laura's MIT graduate friends show up with what look like great big Tonka trucks, that's artificial. That doesn't move the boundary between public and private ownership. Key black letter law. Freshwater and tidal waters have different boundaries, and it's both a difference in terminology. On freshwater, we call it the ordinary high water line. On tidal waters, it's the mean high tide line. And more importantly, they have very different definitions in the law. The ordinary high water line definition is one of the, only a law professor could come up with something like this, right? It's where the presence and action of the water are so common and long continued as to mark upon the soil a different character. Okay, switch back a couple slides. Water boundaries move. The part that got marked years ago may not have enough water on it to stay marked. But that is the definition that still governs in Florida, even though it was adopted back in 1927 by the Supreme Court. The mean high water line, in contrast, the mean high tide line, is mathematically certain. And the Florida DEP maintains a website called Labins, LABINS.org, on which they actually have the day-to-day meter readings from tidal monitoring stations on many of the water bodies around the state, where you can see exactly the elevation that they are tracking and the 19-year averages. It's a great resource, but this is very certain, and it's not as subject to change the way inland waters are. Nobody's ever figured out how we're going to drain the Gulf of Mexico. Okay, Laura touched on this a little bit. Riparian and littoral rights are the rights the waterfront property owner has to make some use of the waters. They are vested common law property rights, vested being the key word. Now, what are they? Well, at common law, and as adopted by the Supreme Court early in Florida's history back in the 1920s, it includes these four rights: the right to have access and contact with the water, to use the waters, to maintain an unobstructed view, and to receive accretions and relictions. through your benefit. A later case back in 2016 clarified that if I have a waterfront property and I describe it, it automatically includes everything that's accreted in front of that to date. So you don't need to separately survey if, for example, I own Lot 1, Block A, and it's waterfront, and there's lands in front of it that accreted. Those go with the deed without a separate legal description, although the better practice is probably to describe it separately. So we start off at common law having 4, and I'm going to go down a bit of a rabbit trail here because it highlights how all of a sudden we've got 2 common law doctrines that come into conflict. Those being the evulsive change doctrine. If it's done with a Tonka truck, it doesn't change the boundaries. With the riparian and littoral rights saying that you have these rights to maintain contact with the water to receive accretions and the benefit of relections. And they can be in conflict. And just think of the beach restoration situation. The law in Florida says if I'm going to restore a beach, first thing the state's going to do is to determine where the beach is today. After it's eroded away and in need of restoration, it's going to reduce that to what they call an erosion control line and record it. And everything that goes in front of that, because it's done with a Tonka truck, is going to belong to the state. Okay, how does that fit with the rights of riparian owners? Sets up an inherent contradiction on those. And that issue was raised in the Panhandle a number of years ago in the Save Our Beaches cases. And the issue that went up on appeal was, does locking in that erosion control line deprive the upland owner of those vested property rights? First DCA says, nope, it's unconstitutional the way our statute's written. Certified the question to the Florida Supremes. The Florida Supremes went through some machinations, but the gist of it was that they said, no, you really don't have, as part of your riparian rights, an inherent right to maintain the contact with the water, just to continue to access it. And if you have to walk across state-owned sovereignty lands because we filled a bunch in front of you, that's fine. A fairly controversial case at the time. They did not clearly address the tension between 2 common law doctrines. They just altered one of them so it fit. This was appealed to the U.S. Supreme Court. Justice Stevens, who owned a condo on the water, recused himself rightfully. It wound up being all 8 upholding the Florida Supreme Court, but for different reasons. 4 of them wanted to get into the question of whether modifying a common law doctrine of property rights is a taking. Question that's never been clearly answered. The others basically agreed that Ken Bell got it right when he wrote the opinion and narrowed the scope of riparian rights. So we'll skip over that. Time marched on. As Melissa talked about this morning, we passed the Marketable Record Title Act in 1963, and that'll become critical in just a second when we start looking at massive changes to water flows in Florida. Now, prior to the Civil War, the state has acquired all of this land pursuant to the Swamp and Overflowed Lands Act. The only way it's ever going to be built out and utilized is people can get to it. How do you get people in the 1850s to lands? You put in railroads. To encourage the railroads, the governor and cabinet said, we've got all this land that you're going to make more valuable. We will guarantee your bond issue to pay for building railroads and giving access to these lands. Now, during the War of Northern Aggression, the Yankees periodically would blow up our railroads, which made it very hard to generate enough revenue to pay off your bonds. And after the Civil War, A mean old federal judge sided with the Wall Street gang and said, nope, state of Florida, you guaranteed these. Governor and cabinet and trustees of the Internal Improvement Fund, I'm going to put you in receivership if you don't pay this. Not a good way to get reelected back then. Maybe it is in this cycle, I'm not sure. Governor Bloxham reached out to one of his fishing buddies, Hamilton Diston, who had made a lot of money making saws, and said, Ham, old buddy, I'm in a tight spot. I need $1 million. And he cut a deal where he sold Diston 4 million acres of land at $0.25 an acre out of the trust to generate the funds to pay off the bonds. So Diston all of a sudden has that, and he sweetens the deal to Diston, basically the same as we did for other railroad creators, and said, Ham, if you put in railroads, if you put in canals, drain these lands, we'll give you even more of our land as an incentive and to pay you for the costs of doing that. And Diston launched into one of the most massive earth-moving projects of the time. He started connecting a series of lakes just south of Orlando, one lake to the next, and each time he connected one, the water levels would equalize. He connected it all the way down to the Kissimmee River, which flows into Lake Okeechobee. Then he trotted around to the south side of Lake Okeechobee and connected Lake Okeechobee to the Caloosahatchee River, which is a beautiful boat ride if anyone's ever done that. You can cross entirely across the state. When he made the last connection to Lake Okeechobee, the water level in the Orlando lakes dropped 11 vertical feet. Now, as flat as Florida is, dropping 11 vertical feet, how much land was exposed? And while he wasn't using Tonka trucks, those were all evulsive changes that resulted in exposing a bunch of sovereignty lands. So our rule is what? Evulsive change doesn't change the boundary. And Diston wasn't the only one doing this. Baron Collier cut some major canals across the Everglades. The Corps of Engineers came along and cut all sorts of drainage projects, all of which altered the natural water flow and the water levels in key parts of our state. All evulsive changes didn't change the boundary. Now, at that time and for many years thereafter, we had some very lawyerly ways of deciding the title issues, the real property title issues. You could actually get summary judgment based on the Marketable Record Title Act, on the notion of legal estoppel. Recall that I said if you didn't have meandering at the time of the original survey, the deed came out for the entire section or quarter section or whatever you were buying. That was a basis for summary judgment, and these all were being upheld at the appellate levels. They were upholding it on equitable estoppel. It ain't right to come and claim that just because somebody drained it with our encouragement that you don't own it. And they based it on contemporaneous determination by those surveyors. And from a title perspective, all was right with the world. Then we get to an outfit called Coastal Petroleum. In the 1940s, our governor and cabinet noticed that the Texas folks had drilled some offshore oil wells in the Gulf and were generating a lot of royalties from it. It meant they could keep their taxes down and keep getting reelected. Wonderful idea. Governor and cabinet said, I bet we've got some in the Gulf too. And they entered into an oil, gas, and mineral lease with an outfit called Arnold Oil Company. And it also included lands up and down a whole laundry list, multiple page list of lakes and streams and rivers throughout Florida, as well as up and down the Gulf Coast. They never found much. No surprise, we still don't have much oil in Florida. Years later, Arnold Oil Company is being acquired by Coastal Petroleum. Some poor junior associate has to read through all of the due diligence materials, I'm sure in an unair-conditioned warehouse. And he dredges up this old lease. And he says, well, we never found oil and gas, but we found a bunch of minerals called phosphate. And Arnold Oil Company put together a lawsuit claiming that the Peace River, which is the north-south one being shown here, and all the phosphate around Bartow that was found, but for all the evulsive changes, the drilling, the drainage, all of that exposed all this land, would really have been 3 miles wide. And all the phosphate that was mined in that 3-mile stretch was really ours under the lease. Thank you very kindly. Please pay us $3 billion. Now it went to trial. Judge Green and Bartow said, nope. Marketable Record Title Act, equitable estoppel, legal estoppel, contemporaneous determination. Phosphate companies win, Coastal loses, summary judgment granted. Went to the second DCA, same ruling. Somewhere between the second DCA and Tallahassee, it became an environmental issue. And by that, it was somebody trying to steal our rivers. Of course, nobody had ever really mined underneath the Peace River. It was too difficult. They were mining on either side of it in lands that had big oak trees on them, were perfectly dry. But by the time it got to the Supreme Court, it had changed, it had morphed. And the Supreme Court held all those 4 bases, MARTA, equitable estoppel, legal estoppel, don't work as applied to sovereignty lands. And then they sent it back to Judge Green and said, Judge Green, figure out, was this a navigable water body on March 3, 1845? And if it was, how wide would it be today had nobody ever made any evulsive changes? Judge Green retired shortly thereafter. No, actually, he dealt with it as best one can, given the absence of many live witnesses at that point. That's the current state of the law on evulsive changes to sovereignty lands in Florida. We've got a great deal of uncertainty as to the inland water bodies. Now, we've had several attempts over the years to deal with the prospect of filling. Going back to 1856, we had a riparian act that said basically, if you fill, it's yours. We wanted to encourage that. We wanted to encourage people to wharf out to make the water bodies, particularly the river system, navigable. There was a fundamental defect in it. It required you to own to the low water mark. Nobody in Florida owns to the low water mark. It got reversed in the 1920s. Somebody pointed that out, and they immediately passed the Butler Act, which said basically the same thing. If you fill it, if you improve out into navigable waters of various types, it's yours. It also covered permanent improvements, wharfs, piers, houses out over the water. It vested automatically another non-record transaction that still creates uncertainty. Because what happens if that dock later blows away or gets taken down? Well, you might still own it, or the lands that used to be under it. That ceased to be the law in 1951, except in Dade, Palm Beach County, and it was formally repealed in its entirety in 57. Our developers didn't get the message. They continued to fill mangrove swamps. Anybody here from Naples? I saw Sam earlier. Port Royal in Naples. Much of that was filled after the Butler Act was repealed. Since it was filled using Tonka trucks, what does that mean? Well, it didn't change the boundaries. And after the Coastal Petroleum case, this is the reason you have that really ugly sovereignty lands exception there. Attorney General Bob Butterworth decides he's going to assert the state's rights to many of these canal front communities. And he picked 3, one in the Upper Keys, one in Hudson, and Port Royal, and reached out to the title companies that had insured them and said, basically, if you pay me policy limits, I'll agree that the state will quit claim their interest to these homes, some of them quite valuable, to the proper owners. But otherwise, they're ours, and we're going to assert the ownership. The title industry did not see the humor in that. The real property section didn't. It led to a multi-year effort to get legislation fixing that passed, which ultimately passed in 1993 and became 253-12 sub 9 and sub 10 that you're probably familiar with. And that, yet again, created a non-record vesting of title. And it basically said, if it was filled before 1975, and you can document that, we picked a year in which we had systematic overflights and aerials, then it automatically vested in the landowner with relatively few exceptions. The exceptions are spelled out in your materials. It has, for the most part, worked very well. I'm not aware of any claims as to title-filled lands subsequent to that. Now, inland properties, we still periodically see them. We saw a bunch of them when they went to rekink the Kissimmee River. One of the red lines I showed was Hamilton Distance, where he had connected things. Subsequent to that, the Corps of Engineers decided to improve it and straighten it out. And of course, that drained a lot of land. And when they went to rekink it, of course, it was going to start flooding lands. And the state of Florida said, we don't really want to pay for all this land we're going to flood. We think we already own it. And they started making those claims on inland waters. And several cases out of it, and they ultimately compromised and settled those. So that's the other theme. We've had several efforts to fill, to encourage people to utilize our water resources around the state and to protect the property rights relating to that. And those are the 3 big ones: the Riparian Act, the Butler Act, and the 1993 legislation. I'm not going to go into the details on that. Laundry list of exceptions. The 93 Act only applies to tidal waters. It's got to be up and down daily. It only applies to filled lands, not permanent improvements, not wharfage, not docks extending out. The filler does not benefit by the act. So that creates a problem if somebody who owned it in 75 or before still owned it in 93. It may not have vested. We have not seen that case tested. It doesn't apply to spoil islands. It doesn't apply to anything that had previously been judicially determined to be state-owned. There's only one of those that we could find. It doesn't apply to anything on a state acquisition list. Guess what? There is no such thing as a state acquisition list. Good legislative drafting. It doesn't apply to state or local recreation areas. Well, that probably doesn't matter because the state owns it either way. And it didn't apply to shore protection structures, meaning the groins, the rock riprap that you see sticking out into the water didn't gain title. And I'm actually 2 minutes early this year. The last piece that's important about that was we recognized we were creating a non-record conveyance. We included a provision in the law that allowed you to have it surveyed based on the aerials from 75 and to have the state issue what amounted to a deed codifying that legal description. That's well worth doing because it will have changed in future years. Thank you for the time and your attention.
Our speaker for the next segment is Drew O'Malley, and the segment is on land trusts. And Drew is someone who lives, he has a broad practice, but he lives and loves land trusts. He wrote the statute, he cares. When I was early and young in the section and Drew was president, chairman of the section, of this section, he made land trusts a priority. He had a whole section on it, and he taught me land trusts. And I have land trusts going on in my practice now, and I know what's going on because of what Drew taught me. He is a member, he's an ACRL, he's the past chair of the Florida Bar Foundation. He's a broad spectrum real estate lawyer, and today you're really going to learn land trusts. So, Drew.
Thank you, Lloyd, and thanks to everyone out in the room, too. I realize that you've come in on a beautiful Saturday afternoon after lunch to listen to me talk about land trusts, and despite what Lloyd says, land trusts may not be the most fascinating topic you'll hear over the course of 2 days, but I am engaged with them. And a lot has occurred in the world of land trusts in the last 10, 15 years. First, back in 2006, the legislature passed a substantial revision to the Land Trust Act, which is Chapter 689-071. And although the legislation was intended primarily to codify existing law, it answered a number of open questions, provided for some new features that were not found under the previous iteration of the statute. Then there have been a couple of court decisions in the last 10 years that affected not only land trusts, but in several instances, Chapter 736 trusts. Lastly, a major revision to the Land Trust Act was enacted back in 2013 to address the issues that arose out of those cases. I'm going to address the significant cases, the statutory revisions, but I'm also going to discuss how you create a land trust, the basic documentation for formation and administration, the principal uses and applications, why you want to consider a land trust, and then some pitfalls that I've learned to avoid. People in this room probably know that traditionally this seminar has been held in Orlando. And I always used to note it was kind of serendipity because Orlando might be the sort of sleepy, dusty, mid-central town that it once was, were it not for the land trusts. Disney made very shrewd use of land trusts back in 1964, recently enacted statute to assemble the land that's now Mickey's home. Land trusts are sometimes called Illinois land trusts because they were originally created under the case law of the state of Illinois over 100 years ago. And I've cited some of the, of course, significant Florida cases in your materials, but also Illinois cases involving land trusts because Florida courts consider Illinois case law to be persuasive authority. 22 other states explicitly recognize land trusts, either by statute or case law. If you're really interested, contact me after the seminar and I can provide a chart describing the status of land trusts in other states. First, let's discuss what a land trust is, some of the terms that are used in connection with them, and some basic requirements to be aware of when forming them. The 2013 Revised Act, a copy of which is included in your materials, contains definitions of trustee, beneficiary, and land trust, and explicitly notes that a land trust is not the creation of an entity, but is, and I'm just going to quote from the PowerPoint, any express written agreement or arrangement by which a use, confidence, or trust is declared of any land or of any charge upon land for the use or benefit of any beneficiary under which the title to real property, including but not limited to a leasehold or mortgage interest, is vested in a trustee by a recorded instrument that confers on the trustee the power and authority prescribed in FS 689-073, under which the trustee has no authority other than, and I'm just going to summarize from here on out, first, following the orders of the beneficiaries or holders of power of direction; two, selling or disposing of the property on the termination of the trust; and performing ministerial or administrative functions as provided in the trust agreement or as directed by the holder of the power of direction. That last provision that I mentioned, the limitation of the duties of the trustee to ministerial or administrative, is new under the 2013 Revised Act and is intended to differentiate the role of the land trustee from that of a Chapter 736 trustee, who typically has much broader powers, discretion, and fiduciary responsibility. The 2013 Revised Act also recognizes that many land trusts that predate the effective date of the Act, which is July 1, 2013, confer on the trustee much broader powers than ministerial or administrative, and the Act grandfathers in those pre-2013 trusts with some caveats. All right, in addition to the statutory definition, you'll see on the PowerPoint what I think is a good practical summary of what a land trust is, as provided in an old Illinois case, Robinson versus Chicago National Bank, that's cited in your materials, that says that a land trust is an arrangement where first, both equitable and legal title to an interest in real estate is held by a trustee. The interest of the beneficiary is personal property. Let me add a caveat to that. In Florida, it is personal property as long as the beneficial interest is designated as such in either the recorded instrument or the trust agreement. We'll get into that later, but it can be personal property or real property. And third, the beneficiary or any person designated by the beneficiary has the exclusive power to direct the trustee in dealing with title, the exclusive control of management and operation of the property, and the exclusive right to the earnings from the property. It's worth repeating that second point. The beneficiary, or any person dealing with the beneficiary, has the exclusive control of management and operation of the property, not the trustee, the beneficiary. This authority, again, is referred to as the power of direction. Now, those of you out there who, unlike me, have paid attention, actually, in trusts and estates in law school, may be thinking, well, wait a minute, what about the statute of uses that voids dry trusts if the trustee has no real power or authority? Well, you would be right, except that the land trust is not an ordinary common law trust. It is a creature of statute, and the 2013 revision expressly recognizes that statute of uses does not apply to land trusts. Okay, let's talk about creation of land trusts, not the biblical sort. The provisions of Section 689-071 set out the basic requirements for the creation of a land trust, and those are: one, every deed, mortgage, lease, or other instrument. And again, it's worth noting that you can hold a mortgage or leasehold interest in a land trust, transferring any interest in real property to any person or statutory entity as trustee for a named trust which does not name a beneficiary and which under 689-0731 confers on the trustee, and again I'm going to quote from the statute because this is significant language, as you'll see in just a bit, quote, the full power and authority to protect, conserve, and to sell or to lease or to encumber or otherwise manage and dispose of the real property. is effective to vest the trustee with full rights of ownership in the real property with full power and authority as set forth in that recorded instrument. So, if your recorded instrument meets those criteria, and your recorded instrument is typically going to be a deed, you've formed a land trust. And the deed that's in your materials as Appendix C includes that language and more, and we'll discuss the deed later. Now, it's important to remember that the land trust is actually created by that recorded instrument. Typically, the deed could be a lease, could be a mortgage, which conveys title to the trustee. It is not created by the trust agreement itself. Execution of a trust agreement without recording an instrument into the trustee is just a nullity. Now, I've mentioned that under the revised statute, the instrument creating the trust must contain, that's Chapter 689-0731 language about the powers of the trustee to protect, conserve, etc. That was not an express requirement under the pre-2006 statute, and the failure to include that language has been the subject of several Florida decisions. One of the more interesting cases, at least for me, where the powers language was a critical issue, was in a celebrity tabloid type case, divorce case out of Palm Beach, of course, in which I was retained as expert witness for the wife. The case involved over $100 million of commercial property. One half of the beneficial interests in these land trusts were assigned by the elderly, wealthy real estate mogul husband to his much younger, very attractive, blonde, German, literally mail-order wife. This was a simpler pre-Tinder time when old guys used to search for partners via snail mail. As these stories go, bliss turned to scorched earth. Wealthy mogul files for divorce and alleges that those land trusts never existed. Why? Because the deeds into the trust failed to contain that power and authority language. Hence, the husband alleged the assignments to the wife were a nullity and the wife was entitled to nothing. I testified, and the trial court ultimately held that although the inclusion of the language is good practice, it was there for the sole purpose of providing assurances to third parties dealing with the trustee as the trustee's powers. If the language was included in the instrument, then the third party did not have to inquire into the power of the trustee or the provisions of the trust. However, the failure to include the language did not, in my opinion, void the trust. The trial court bought my interpretation of the statute, and the wife won. Subsequent to that case, both the Florida Supreme Court and the Florida legislature indicated that they were not impressed with my opinion. I think if the governor had had any role, he would have spanked me as well. In 2006, the statute was revised to make it clear that the express language regarding trustee powers must be included. And the 2013 statutory revisions, in response to a Florida Supreme Court decision that we'll talk about in just a moment, moved that powers language out of the land trust statute and into 689-073, which enables the inclusion of that language both in land trusts and in Chapter 736 trusts. A couple of quick asides on that case. Rob Stern, my good friend who spoke to you yesterday on tax liens and tax titles, was expert witness for the evil real estate mogul husband. And secondly, and tragically, a week after the trial court decision siding with my client, the husband lured my client into a meeting with him to which I was invited, fortunately did not attend, in which he then shot my client to death and critically wounded her investment advisor. After a very high-profile Palm Beach trial, he was convicted of murder one and died in the penitentiary just a few years ago. So anyone who tells you that real estate doesn't have exciting moments has not dealt with that. Yeah. And that is a good segue into the case of Brigham versus Brigham, which is cited in your materials, which was decided by the 3rd DCA in 2009. Rehearing was denied by the Florida Supreme Court in 2010. Once again, although I convinced the trial court in the tabloid case that the restitution of the trustee's powers was unnecessary to create a valid land trust, the 3rd DCA, and by implication the Florida Supreme Court, since it denied review, rejected a similar argument in Brigham, a case that created problems for attorneys creating both land trusts and those creating Chapter 736 trusts. Brigham, in my opinion, is a case of bad facts making bad law. Without spending too much on the very lengthy and convoluted background of the case, it involved the legitimacy of a conveyance of over 600 acres of North Carolina property. Why you would put North Carolina property in a Florida land trust is a whole separate issue. That was transferred from an inter vivos trust, not a land trust, that was for the sole benefit of a widow. It was conveyed from that into a Florida land trust by the trustee, who also happened to be the widow's son, a Florida attorney, and the sole beneficiary of that land trust. When the widow died, the conveyance by her into the land trust for the benefit of the son, attorney, sole beneficiary was, not surprisingly, challenged by the other beneficiaries. The 3rd DCA found that that son's actions constituted improper self-dealing between an attorney and a client under the Florida Bar's rules of professional conduct, and also held that it amounted to a breach of his fiduciary duty as trustee, since he did not obtain court approval to convey trust property for his benefit as required by Chapter 737, now Chapter 36. Of greater interest for our purposes was the court's finding that since the deed from the mother-in-law's inter vivos trust to the land trust did not contain the trustee's power and authority language, it did not satisfy the requirements of 689-071 and thus did not create a land trust. The primary issue arising out of Brigham for practitioners forming land trusts or Chapter 736 trusts was that holding that the failure to include the power and authority language resulted in the failure to create a land trust, but by implication, including that language in your deed did create a land trust. That implication created a lot of anxiety for practitioners who for years had been pulling that power and authority language out of land trust statute and putting it into their deeds into 736 trusts to avoid having to produce the trust, or at least an affidavit as the authority of the trustee, when it came time to convey or finance the property or anything having to do with the title. Those practitioners faced the prospect of having inadvertently created a land trust rather than a 736 trust, which of course is an entirely different beast with very different limitations, different obligations and fiduciary duties. To address the consequences of the Brigham decision, the reputable section worked on a legislative fix for nearly 2 years, which resulted in the 2013 revised act. In your materials, you'll find in Appendix A, there's a copy of the 2013 revised act. There's also a copy of 689-073, which is where the powers language is, and a copy of the House bill that kind of highlights the differences between the pre-2013 Act and the revisions. The principal revisions, as noted on the PowerPoint, are to address the conundrum that I mentioned for 736 trust practitioners created by Brigham, which again implied that the inclusion of the powers language created a land trust. Again, the deed powers language was extracted from the land trust statute and plugged into 689.073. This enables the inclusion of that language not only in land trusts, which is mandatory to create the trust, but also into deeds into Chapter 736 trust, which is optional. Chapter 689.073 also provides that third parties dealing with trustees in connection with trust property in which the deed powers language is included in the deed have no duty to inquire into the trustee's authority and take free and clear of any claims by the beneficiary. Quick caveat on that. Alan Fields, who's one of the speakers in the past, has spoken on homestead law. His opinion, and I've learned not to doubt Alan's opinion, he's far smarter than I am. He believes that if you're conveying or examining a conveyance of homestead property, you do need to confirm the authority in order to verify that the trustee did in fact have appropriate authority to convey homestead interests. The revisions limit the powers of the trustee of a land trust to essentially, one, following the orders of the beneficiaries or holders of a power of direction, disposing of the trust property when the trust terminates, and ministerial or administrative functions. And again, that's to distinguish the role and responsibility of the land trustee from the much broader role played by the Chapter 736 trustee. As noted, the Act contains provisions that grandfather pre-2013 land trusts, many of which have much broader grants of authority to the trustee, so that those were not terminated or rendered void by the 2013 revisions. The revisions also allow the designation of the beneficial interest as either personal property or real property, and provides that a UCC filing is the appropriate way to collateralize the beneficial interest if it's designated as personal property, whereas a mortgage would be the appropriate instrument to encumber a beneficial interest if it's designated as real property. I believe that in most instances, a designation in your instrument of the beneficial interest as personal property will be the preferred choice, as it facilitates a number of the kind of unique, cool uses for land trusts that I'll be discussing in just a bit. And a detailed examination of all the changes brought about by the 2013 revision is included in your materials. All right, we've talked about the characteristics and formation of a land trust and the issues resolved by the 2013 revisions arising out of the failure to include that powers language. Now let's discuss the essential documents used in forming and administering land trusts. As I mentioned, typically a deed into the trust is the document that creates the trust and conveys title into the trustee. As noted, be sure it includes that powers language out of 689.073. A formal warranty deed creating a land trust is included in your materials as Exhibit C. If at all possible, I make provision in my deeds for a successor trustee. Now, the revised statute provides a procedure for appointment of a successor trustee if one is not named in the deed. And under the revised statute, the appointment of a successor trustee can be accomplished by recording a declaration designating the successor, and the appropriate parties to execute that declaration depend upon whether the successor was or wasn't named in the trust agreement. In my opinion, again, if at all possible, best practice, consider naming a successor trustee because it avoids the sometimes cumbersome declaration process. The trust agreement is the second major document necessary for the creation of a land trust, and it is the agreement between the beneficiaries and the trustee that establishes the terms of their relationship. And a sample land trust agreement is included in your materials as in Appendix B. Some points to remember about the trust agreement. First of all, it's not recorded. Doing so defeats one of the primary advantages of a land trust, which is confidentiality of the beneficial owners. The trust agreement should name each of the beneficiaries, the percentages of ownership, and how they are held. Tenancy in common, tenancy by the entirety, in an entity, what have you. Be sure to accurately reflect what property is in the trust or is anticipated to be conveyed into the trust. And again, as I mentioned, the trust can have a mortgage or a lease or other interest in real estate as its ray. The power to manage the trust property is in the beneficiary or beneficiaries under the 2013 revisions. And if the trustee has any powers that exceed ministerial or administrative, that's going to kick your trust out of the land trust statute and into Chapter 736, which again is a different thing entirely. The new act does not define what powers are ministerial or administrative. We wrestled with that. We tried to come up with an inventory, but we just could not anticipate all the potential ministerial or administrative actions. As a practical matter, the exercise of any significant level of discretion by the trustee will probably be the criteria. Paying taxes or insurance on trust property shouldn't be a problem. Negotiating these loans collateralized by the property, leases, contracts for sale, almost certainly is going to kick you out of the land trust statute. The third critical document for trust formation, in addition to the deed and the trust agreement, is a beneficiary agreement, and a very rudimentary example is included in your materials. While the trust agreement may address some of the understandings between the beneficiaries, these agreements, in my opinion, are better and more thoroughly addressed in a separate beneficiary agreement that's similar to a shareholders agreement, partnership agreement, LLC operating agreement. You'll find a lot of similarities. Now, many investors who hold property in a land trust probably have not entered into any formal agreements other than the bare trust agreement. And provided that there's only one beneficiary or a small group that is in complete agreement as to the goals of the venture, and that venture is pretty straightforward, that may suffice. But in leaving their relationship unstated, they've really created kind of a peculiar beast. It's part tenancy in common, part partnership, and the beneficiaries are going to have to put their faith in the statutory and case law pertaining to both if deaths, divorces, disputes, or other problems befall them. I've noted on the PowerPoint some of the potential problems for beneficiaries that are left unresolved if you rely solely on the provisions of the typical trust agreement. What are the primary issues you can address and resolve in a beneficiary agreement? Management. The beneficiaries can equally share in proportion to their interests, the management of the property via voting. They can limit it to a certain group or an individual beneficiary. They can appoint a professional manager. Again, be sure to address what their choices are. Record maintenance. The agreement should provide for detailed record keeping of income and expenses for income tax purposes and provide for periodic financial statements. Contributions of capital. Often there's no more fraught issue with multiple constituent real estate entities. A lot of ventures are going to require additional capital contributions to pay taxes on raw land, or make repairs that are a tenant's responsibility if it's rental property, or make capital improvements. What happens if your co-beneficiary can't or won't pay his or her proportionate share? Well, in the absence of a beneficiary agreement that addresses that issue, the co-beneficiary who advances those funds really does so at his or her peril. He or she has a common law right of contribution against the defaulting beneficiary. It may have an equitable lien, but that advancing beneficiary is going to have to prove that those improvements were necessary for the preservation or use of the property. The beneficiary can't just make permanent improvements that are not absolutely necessary without the consent of the other beneficiaries if he or she expects to be reimbursed. In order to avoid litigation or have some certainty as to outcome, be sure that's covered. Hand in hand with contributions are remedies of the co-owners. If a beneficiary doesn't pay for approved expenses, you can have a default clause. Again, this is similar to operating agreements and buy-sell agreements. The amount due and unpaid can be designated as a loan by the advancing beneficiaries. You can limit the voting rights of the defaulting beneficiary. You can eventually, if the default persists, provide for forfeiture of the beneficial interest. It really is varied as your imagination or your client's imaginations can provide. Transferability of beneficial interest. Land trust is often employed due to the ease of transferability of beneficial interest. Any beneficiary may assign his or her interest in the property to anyone he chooses. The obvious disadvantage is that the remaining beneficiaries may end up with someone they don't like and never anticipated as a co-owner. The beneficiary agreement can provide for restrictions on the right of transfer with options, buyout provisions, again, similar to a buy-sell agreement. Death or incompetency of a beneficiary. There's another situation in which a buyout provision is advisable. Usually, this clause is going to require an appraisal to be made to be sure that the estate of the deceased or the guardian of incompetent gets fair market value. You can fund that with life insurance payable to the trustee. All right, well, I've spent the last 25 minutes or so telling you what land trusts are and how to form them. You're probably sitting out there thinking, well, that's great, that's interesting, but so what? Why would I want to use one of these things? So let me tell you about their interesting uses, most of which stem from the unique fact that the beneficial and legal title to the real property is in the trustee, whereas the beneficiary has a personal property interest provided that it is designated as such in the recorded instrument or the trust agreement. It can be a real estate interest, but although there's some reasons, unique reasons why you might want to do that, in virtually all instances, designated as personal property. Privacy of ownership. One of the most significant attributes of a land trust is the fact absolutely no public record will indicate the interest of the beneficiaries. Disney liked it for that reason. Foreigners love it to conceal their assets from seizure or taxation by authorities in their home country. Lots of reasons why confidentiality may be attractive. I'd also note, at least according to my interpretation of the Corporate Transparency Act, which is going to be affecting entities here soon, it does not apply to land trusts. Why? Because the determining factor as to applicability under that act is recording with or filing with a state authority to create the entity. Land trusts, there's no filing with state authority. So again, that's Drew O'Malley on Corporate Transparency Act. I have not seen any controlling authority on it, but I think that's proper interpretation. Limited exposure to judgments and liens. Title of real estate held in a land trust is not subject to judgments and tax liens against the beneficiaries. So in the situation where there are multiple owners, the land trust affords protection to title. Where there's a judgment or lien against one of your co-owners, the lien attaches to the beneficial interest of the beneficiary, but it does not affect the title to the real property. Similarly, title to real estate held in land trust is not subject to a lot of other factors that can befall the personal lives of beneficiaries: death, incompetency, bankruptcy, marital disputes. None of those will screw up the title to your land trust. Mortgage loans can be easily structured without personal liability, assertable against the beneficiaries. If only the trustee signs the note and the loan documents, they're enforceable only against the real estate. You've essentially got non-recourse financing. And the revised act makes it clear that a trustee can be a creditor of the trust without that being a breach of fiduciary duty, because you will find some financial institutions that will act both as trustee but also fund trust operations. And the beneficiaries are not liable for the debts or other obligations of the trust unless they affirmatively assume them. We mentioned ease of assignment of beneficial interests. Again, since it's if designated as such personal property, you can sell or transfer without recording a deed, just a simple unrecorded assignment. I would note, however, as I believe Bert Bruton mentioned yesterday in his discussion on documentary stamps, that does not avoid the payment of documentary stamp taxes. Florida Department of Revenue closed that loophole a few years ago, well, many years ago, and the assignment of the beneficial interest is a taxable event. Beneficial interest can also be used as collateral. Again, if it's real property, you would have to file a mortgage against it. If it's designated as personal property, a note, UCC 1, and a financing statement. In my personal experience, if you're dealing with conventional lenders, lenders being lenders are going to do a belt and suspenders approach. They're going to take a mortgage against the trust property and a collateral assignment of the beneficial interest. So they have more than adequate security. Along those lines, let me note the 1997 case of Kirkland versus Miller, which is cited in your materials, in which the second DCA held that when the parties to a land trust transaction intend that the conveyance into a land trust is intended as a financing arrangement, the land trust will be deemed to be a mortgage subject to the rules of foreclosure. This is another case of bad facts making bad law and an attorney behaving badly. In Kirkland, a real estate investor attorney got the wise idea to sell and finance resort property by giving the buyer a beneficial interest in a land trust in which the attorney investor was the trustee, with a note payable to the attorney investor for any debt. If there was a default on the debt, the investor just sought ejectment against the buyers, claiming they had no ownership interest. The second DCA did not like that and held that in order to reclaim title to the property, the investor would have to foreclose, which undoubtedly created some real problems for the attorney investor, since he didn't have a mortgage. He had a land trust without any of the typical provision of a mortgage to work off of. I would note that this same scheme continues to today's date. I was an expert witness a few years ago with two competing groups of Russian investors with luxury properties out of Miami that were placed in a land trust. And the one group that controlled the trustee, when they alleged a default, just said, well, you don't own beneficial interest owner, you don't own anything. So it's that you will see that scheme from time to time. That was also another rather frightening case, since we were told we might want to be concerned about black sedans pulling up in front of our offices at some point and Russian gangsters getting up. That's another matter. Partition is not a remedy available to the beneficiary. This feature may be significant for preserving family farms and legacy properties. If you're really interested in that topic, I co-authored an article in the spring 2010 ABA Real Property Trust and Estate Journal titled Using Land Trust to Prevent Small Farmer Land Loss. I'm told by the hardy souls who've actually read that article that it is a great alternative to Ambien if you suffer from insomnia. Testamentary and estate planning uses. Transfers of title on death of beneficiary in a land trust can be much less complicated, since if it's designated as personal property, not real estate, it can be, you can avoid ancillary administration in Florida, since the beneficial interest is personal property and thus can be disposed of by probate in the beneficiary's domiciliary state. I'd add, as a caveat, however, that in some instances, that might not be a good idea. After I made this point a few years ago in this same seminar, an attorney who is admitted in New York indicated that ancillary administration in Florida can't avoid having Florida real estate owned by New York residents included as part of their estate for New York real estate, for New York estate tax purposes, which I understand can be a significant chunk of money. Let me also note an article in the March-April 2019 Florida Bar Journal titled The Problem with Pocket Deeds and a Review of Alternatives, suggesting the use of land trusts as an alternative to ladybird deeds, especially where confidentiality may be significant. Okay, let me briefly note the distinction between Chapter 689.071, which is the land trust statute we're discussing, and 689.07. Chapter 689.07 covers the situation in which a grantee is named. The words trustee or as trustee appears after their name, and no further mention of a trust agreement or powers of the trustee is recited in that deed. This does not create a land trust. In fact, it really doesn't create anything. The trustee in that instance has full legal, equitable, and beneficial title to the property. The trustee designation is disregarded. One quick caveat to that, though, that is noted in the case of High School versus Morris. That's 2015 decision, 182, Southern 3rd, 714, holding that if the actual trust agreement or memorandum of trust is recorded before or after that 689.07 deed, the land trust can be established and enforced against the trustee. All right, well, by summary, the important matters I hope I've conveyed and that you can remember are the way a land trust is created, the deed into the trust agreement, and in most cases, particularly where you have multiple beneficiaries, a beneficiary agreement. The land trust beneficial interest can be held by a corporation, partnership, LLC, individuals, and the trustee can be an individual, corporation, LLC, limited partnership, or bank. Remember, the deed of conveyance should specifically state at a minimum the power and authorities language. The power of the trustee should not exceed ministerial or administrative functions. Do not name the beneficiaries in the deed. And remember the unique attributes: confidentiality, installation of title to the property from judgments, liens, bankruptcies, deaths, financing using beneficial interest rather than a mortgage, avoidance of partition, and various estate and probate uses. Again, thank you all for coming back in to listen to me today, and best wishes to all of you on the exam. If you have any questions afterwards, don't hesitate to call me. Thank you.
One of my favorite quotes, and it gets to attribution to all kinds of different people, is this, when someone wrote someone a letter and said, "I apologize for the length of this letter. If I had more time, it would be shorter." I think it's Mark Twain, but you hear it from lots of places. Well, that's what Jacob Kramer has done. What he has done is he has given you a set of his PowerPoint is someone that spent the time and really consolidated it into a show that works. Totally different than the material, and it just shows the piece. Jacob is shareholder, at Stearns Weaver, practices in the zoning and governmental and environmental areas. The key piece I love in his bio, because it's the same thing we talked about with Bob Stern, so the people that you grew up in it differently. Bob was and the banks. Jacob grew up in his family timber business, has a concern and input in the agricultural areas, and I think his materials are great, and it's going to be, this second year I've heard the lecture, I think it's going to be great. Enjoy.
Thank you. Good morning. Can you all hear me in the back okay? Thanks. I'm getting over a sinus infection, so I can't project quite as much as I'm used to. My name is Jake Kramer. I'm a land use and environmental attorney and property rights litigator in the Tampa office of Stearns Weaver. As was mentioned, I have a background in agriculture and a background in professional planning. I worked at the former Department of Community Affairs and also have a master's in urban planning. So that's how I ended up in the land use business. What I've done and organized the presentation is, when I first put the presentation together several years ago after doing the materials, I couldn't make it through my own presentation myself without falling asleep. So I decided to do something a little more interesting that I think has worked well, and be interested in your feedback. But I organized this into pitfalls, land use pitfalls for the real estate practitioner, because what I'm hoping is after you all pass the exam, because you're going to pass, because you're here with us, and after you pass, you have something useful for your practice in the day-to-day. And frankly, you need to know when do you call people like me. Really, as real estate practitioners, you should have a land use attorney on speed dial. The first and most critical thing to know about land use in Florida is it all starts with the comprehensive plan. The comprehensive plan, the case law describes it as a land use constitution, and the courts mean it. Once a local government adopts a comprehensive plan, everything it does related to development must be consistent with that plan, period. That includes land use decisions, infrastructure planning decisions, and even budgeting decisions. All of that flows from a U.S. Supreme Court case in the early 1900s called Euclid v. Ambler, where the U.S. Supreme Court said local governments do have the power to initiate zoning measures, but it has to be done rationally and in accordance with some kind of a comprehensive plan. That doesn't necessarily mean like a plan like we have in Florida, but it has to be according to some general scheme. It can't be arbitrarily made up. So pitfall number one, we have planning and we have zoning. I get calls all the time from landowners who say, I want to build X, I've reviewed the zoning code, and it says I can build it, but the local government is now telling me I can't. Why is that? Sometimes that's because the comprehensive plan doesn't allow it. So you always have to think, starting with land use decisions, what does the comprehensive plan say? That's your first stop, not zoning. Does the comprehensive plan allow this potentially? And then you look at zoning, land development code, maybe the code of ordinances, maybe policy and technical manuals, but it all starts with the comprehensive plan. And those documents, such as the zoning code or land development code, they all have to conform, obviously, with the comprehensive plan, or they're void ab initio. So that's where you start. The comprehensive plan is providing policy guidance for the local decision makers in making the decision. So it doesn't necessarily have, a lot of times the language feels, for lawyers, it feels pretty squishy because it's policy guidance. It's not a prescriptive manual for exactly everything that has to occur to get some sort of land use approval. And that's on purpose. So zoning, what probably we all hear about more in the day-to-day than the comprehensive plan, is simply a scheme of dividing up land into certain types of uses. The most familiar type to you all will probably be what's called Euclidean zoning, going back to that case Euclid v. Ambler, which is districts that allow, say, commercial or industrial or residential, or becoming more common now, mixed-use districts that may allow some combination of those. And there's a zoning category, it's prescriptive, and if you meet the use and you can meet the setbacks and the other provisions of the code, then as of right, your client can go build that. Where things get a little bit more difficult is when we look at plan development zoning. So they're called PDs, PDAs, PDUs, plan development. Anytime you hear that plan development, what that means is there's a process where the local government and the landowner or developer actually negotiate the specific zoning district for a specific property or properties. They can be, I've seen them as small as a couple tenths of an acre and as large as thousands of acres. And that zoning district includes a site plan that visually depicts where uses can occur, and they may have conditions, but then there's a separate document, usually that's a set of written conditions, and they describe all of that, the how, when, where, why, what, who, what can be developed and when. And so essentially it's a negotiated document that gets approved in the public records by the governing body. Now, I say in the public records, usually, every district is different, but usually that's not going to be a recorded document. But as you can imagine, that might be very important for your client to understand their rights and potentially obligations of things that they must do. And again, zoning and comprehensive plans, the two main chapters you'll need to know. Again, call a land use lawyer if you need to read these chapters. They're really long, they're really hard to understand. But you have chapter 380 that covers what are called developments of regional impact. That's sort of an antiquated, but there are still some out there, but it's an antiquated law for very large regional projects. And then chapter 163 describes how local governments can adopt and amend comprehensive plans and how they can adopt and amend their zoning codes and all the rules and regulations that flow from that. Pitfall number 2 is not understanding some of the key concepts of zoning. And each of these, especially if you're dealing with a project that has dealing with a deal that has structures that are already constructed or are going to be constructed, perhaps during the term of the contract, you'll need to know something about these 4 concepts. And really all of these you can think of in a way as a softening of standard zoning. So standard zoning is very prescriptive. If the code doesn't say that a specific use is allowed, then generally the assumption is it's not allowed. So these 4 concepts, variances, conditional uses, non-conforming uses, and vested rights, are all somewhat of a softening of those concepts, but each of them have different laws and different concepts that govern how they're considered. And I'll say that all of them will likely require both an application as well as staff review and some sort of governing body approval. Perhaps it's by the elected officials, perhaps it's by a single decision maker, or even, God forbid, a citizen body. And those are things that are important for you to understand because as you're drafting your contracts, you should understand if those approvals are to be obtained during the term of the contract, then you need to know what does the process look like. So variances are something that would otherwise not be permitted under the zoning code, except for use. So for example, if I'm working in a residential zone, I can't go to the government and ask for a variance to allow a commercial building because that goes to the substance of what the zoning code actually does and means. So setting aside use, most of you will be familiar with and probably seen projects that need a setback variance. That's probably the most common, right? So the code says, as of right, you can build a home as long as you have a 20-foot setback on the side yard between the edge of the home and the property boundary. But let's say you've got a triangular shaped property. How do you measure that? It's not always clear. Or maybe you have, maybe 3/4 of the property is wetlands. And so to preserve the wetlands, your architect has recommended moving the home closer to the other boundary. That's the type of scenario, sort of the classic scenario for a variance. Now, the case law in Florida for variances is very, very strict. The case law says that you have to demonstrate an exceptional and unique hardship to the individual parcel that's not shared by other property owners in the area. So there has to be something unique to the land, not something unique to your owner, not something unique to your buyer's interest, and definitely not something unique as far as a financial hardship. Financial hardship does not count. So to meet the hardship requirement, the landowner has to show up at a public hearing and present what's called substantial competent evidence supporting the variance, and then the decision maker will have to issue a decision based on only the evidence that's been given in the application and at the hearing. What you should know, though, is that in practice, variances are granted much more frequently than the law, strictly read, would lead you to believe. In most jurisdictions, if you have a competent land use professional or planner helping, or maybe even an engineer helping put together the application, and the government staff doesn't have an objection, and you're not getting a bunch of angry neighbors showing up at a hearing, usually the variance is going to be granted, even if the law strictly wouldn't allow it. So just keep in mind there's a big difference in the practice and the reality, especially with variances. The other big thing to know is that the variance can't be self-created, right? I can't split my parcel into several very strangely shaped sub-parcels and then go cry for forgiveness later through the variance process. Conditional use or special exception, there's sometimes other names. Again, every land development has its own code, but this is sort of what the case law calls them, the conditional use and special exception. So the issue here is, unlike a variance, you are allowed as a property owner this use as a matter of right, but you have to meet specific enumerated criteria in the code. So probably the classic example of this in the case law is a church. Churches are usually allowed in residential zoning districts. However, there are almost always going to be some constraints on how big that church can be. Usually the concern is traffic. Maybe you have lighting concerns, maybe height. You want to make sure the building is somewhat in scale with the neighborhood. So that's the classic. Now, if you meet those criteria, then again, as a matter of right, that use is allowed. So if your client were to get denied a variance versus a conditional use, the case on appeal would be much, much easier for a conditional use as long as they've met those conditions. Sorry, my mother would be horrified here, but I don't want to cough. Non-conforming uses. So non-conforming uses is where the use was allowed when it came into being, but now it's not. The law has changed over time. What the case law says is that in equity, government must, when the law changes like that, they must give the property owner some rights to continue that use for some period of time. There's not a lot of case law on when, how, why that occurs, so there's a lot of debates. But the point is, if your client has a non-conforming use, don't think that it can continue forever. It may very well be subject to some type of amortization when it has to close. It may be subject to regulations that say if it closes, maybe even for a day, then it can't continue, which could be important in the context of a real estate transaction. So generally, I would say if you have a non-conforming use, you should always assume, whether you're representing the buyer or the seller, that you're going to have to take that into account in some way in the real estate transaction. Maybe you need to go get comfort from the local government on how and when that use can continue. Vested rights and equitable estoppel. So this sounds somewhat similar to non-conforming uses at first, but basically the idea is, let's say your client has received an approval from a local government, they're proceeding on the path, they're relying upon that decision, and then something changes. Maybe that's the law that changes. For example, one time I had a client, they got a rezoning approval for a certain type of use, a concrete batch plant. People generally don't love concrete batch plants. They got the approval, they started clearing the land, and lo and behold, the local government then banned concrete batch plants, right? So the conversation then with the local government was, when and how can that use continue? This is an issue where, unlike the other three, if you feel like you're facing an issue of vested rights or equitable estoppel, you really do need to get a land use attorney, a property rights litigator involved, because usually there is a policy decision that's going along with the claim of vested rights, usually local governments are really going to resist those claims. Because essentially, the developer or landowner is saying, notwithstanding what the law says, I can continue doing what I'm doing. In the real estate transactional context, probably the most common way that I think you see vested rights arise is if there is if there's a development agreement between the local government and a landowner or developer under Chapter 163. So if you have an agreement that you're reviewing between a landowner and a government, look to see whether it matches and if it complies with the provisions under Chapter 163 of the Florida statutes. There's a specific statute. If it checks those boxes, then automatically certain rights are vested to the beneficiaries of that agreement. So it's a very powerful tool, especially for large projects, to keep in mind. Pitfall number 3 is not understanding the hearing involved in your deal. So this is very, very important in raw land deals or redevelopment deals. You all hopefully aren't going to be the ones handling the hearings. I wouldn't recommend that. But you need to understand what's coming so that you can protect your clients and negotiate the best deal possible for them on how the deal will unfold and whether it's dependent on these types of hearings. Quasi-judicial hearings are where there's a set of law and you're putting evidence into the record to show that you're complying with those laws in order to gain some sort of entitlement approval. Quasi-legislative is where the governing body is developing policy during the hearing. There's less evidence involved and frankly more opinion, more subjectivity at least. An example of that would be developing a comprehensive plan in the first instance or developing an amendment to it. whereas quasi-judicial would be a rezoning or a variance, for example. There is a third type that's probably less important for real estate transactions for you all to know and draft around, which is a ministerial decision. So a plat, for example, is a ministerial decision. The case law says that if you've checked all of the boxes for a plat under the statute in the Land Development Code, the local government must approve it. Sometimes you get into uncomfortable situations where people show up to local government hearings and oppose a plat, and I have to stand up and tell the Board of County Commissioners that they're obligated to approve it and they can't say no. You can imagine they don't like that, but that's what the law says. Now, the two types of hearings, the two major types of hearings have very different standards of review. Again, this is important for you all if you're working on a project for raw land. Quasi-judicial, these three questions are what a court on review would look at. So your hearing is actually before the local government. And if it's challenged, it goes on appeal to the circuit court. And those are the three questions that the circuit court is reviewing against the record that was developed at the local government hearing. So even though it's a hearing before local elected officials, in my world, I still have to be very careful about developing a record so that we have that if the project is challenged later. There is another type of challenge to quasi-judicial approvals, which is where someone is saying, hey, this rezoning doesn't meet the terms of the comprehensive plan. That type of challenge is subject to strict scrutiny, and it's a de novo appeal to the circuit court. So oftentimes when rezonings are challenged, you'll see two lawsuits, not just one. Quasi-legislative decisions are much more difficult to challenge. I like to say the way to think about it is that the scales of justice are tilted on the side of the government for legislative decisions. It's just fairly debatable. If the government comes into court with any rational reason for what they did, even if that rational reason wasn't talked about at the hearing, the government wins. But comprehensive plan decisions, even though they're legislative, the comprehensive plan decision, let's say an amendment is passed, that amendment has to strictly comply with the remainder of the comprehensive plan. So that standard changes a little bit if you're dealing with a comprehensive plan. Okay. If you take away nothing that I say today, take away this slide. I don't know, and I don't really care if it's on the test, but this slide will protect all of you from future malpractice claims and bar complaints. Please, 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 in Florida, do not assume that entitlements are transferred with the fee to the property. There's a lot of case law out there that says, especially in the case of a DRI, and I think any sort of master planned property, going back to a planned development, I think this case law would apply to a planned development. Do not assume that the entitlements are automatically being transferred with title. You need to make absolutely sure that that transfer of entitlements is being done through the deed or another conveyance, and you absolutely want to address it in your PSA. There are very, very sad tales of woe of landowners who bought large amounts of land with zero entitlements, and then, as you can imagine, got extorted by the master developer when they realized that and came back to ask what happened and that asked for permission to build something. Okay, this is a little bit of a self-plug, right? But every deal you need to look at on sort of a continuum. How complex it is. Are you purchasing an office building on a small property? You know, in that case, probably you can rely on a planning and zoning report. But if you're buying 1,000 acres in a large master plan community, and you need to make sure your client can actually build what they think they can build, bring on a land use attorney. and think about in between. And know what you can and can't find in the public record. Again, this goes back to the comment of plan developments are very rarely recorded. Rezoning decisions are very rarely recorded. Variances very rarely recorded. But all of these things affect the nature of the property rights that your clients think that they are purchasing or selling. So think about that, know where to look for those documents, or at least how to call up the local government and ask for some help along the way. With my last few minutes, I want to mention a few concepts. Some of these were in the material, but some weren't, but I think you should know about them because you'll probably come across these in deals you work on. The first is concurrency. So in the 80s, Florida imported a concept from the West Coast of concurrency, and the idea seemed like a good one, which was at the time that development comes online or opens, certain types of public services need to be available concurrently with that opening. Seemed like a great idea. We had that for a lot of things. Sewer, water, drainage, transportation, schools, a lot of different subjects. It was mandatory for many years, throughout the 80s, 90s, and into the 2000s. When growth management in Florida changed, so growth management was very heavily regulated for many years by the state up until about 2010. Then the legislature started pushing that power back down to the local governments. Concurrency at that point started to become less popular. And so now you'll see some jurisdictions have it, some don't. The key thing to know is if there's a system of concurrency, even if your client has all the entitlements they need to build something, they may run into a utilities or infrastructure issue where they could build their project and actually not be able to get a CO because they can't meet some public utility issue. So just something to be aware of. If your jurisdiction has concurrency and you're dealing with a deal that involves development or redevelopment, just think about that. Ask your clients if they thought about it. Impact and mobility fees is a hot topic. This is an issue where I don't want to get too far into the weeds because the legislature for about the past 10 years has updated the statutes on this every single year. Big picture is developments have impacts on the surrounding community. The best way legally for local governments to ensure that those projects pay their fair share is through impact fees or mobility fees. The thing that's important for you all as real estate transactional attorneys to know is oftentimes you will see deals that involve the transfer of impact or mobility fee credits. That's where a developer has gone out and say built an intersection. The local government doesn't have the money to pay for it, so they say, hey, we'll give you some vouchers for impact fee credits, and you can go see if you can sell them on the market to someone else so that you can get reimbursed for that improvement. Oftentimes sellers in deals, if they have them, they will require the buyer to purchase them. That's fine, but you need to make sure your client, as the buyer, understands how, when, and where can those credits be used. The last thing I'll mention is just preemptions. We're seeing more and more preemptions as the legislature pushed power down to local governments. Some of them made good decisions, some of them made bad decisions. And whatever side of the political spectrum you're on, some of those decisions resulted in the legislature saying, no, you can't do that anymore. If you're dealing with agricultural properties, there are a lot of preemptions. Home-based businesses, that was a hot topic from a couple of years ago, basically making sure people had the right to run businesses out of their homes. The big one that's been on the news this week, the Live Local Act that the governor just signed. I was just talking to some folks in the hallway about it. It preempts local governments from disallowing certain projects that include affordable housing. For certain types of projects, you don't even have to go through the zoning process, whether or not the zoning code actually allows it. So if you're dealing with a development deal, just keep those in mind. So that's all I have. I hope that's helpful. Please contact me if you have any questions afterwards. Thanks for your time.